Hey guys, welcome to our video. This is John Watts. I'm a consumer protection lawyer in Alabama. And I want us to look at a recent federal case from the Middle District of Florida, which is the Tampa area. And it involves a claim by a consumer and then the defendant saying, well, wait a minute, you can't sue me in court. You have to go to arbitration. And so the court's going to look at whether or not the defendant can force or what's called compel arbitration. So the background of this case is there was a Hyundai purchased and the finance agreement was eventually assigned to PNC, that's the main defendant here, bank. And then the consumer, Sullivan, falls behind on her payments and the car was repossessed. And then there's a lawsuit brought in state court. So here are the claims brought in state court. That we've got the Uniform Commercial Code, UCC, was violated. The Fair Debt Collection Practices Act, FDCPA, was violated. Florida Consumer Collection Practices Act, which is kind of the equivalent. It's not 100%, but it's very close to the federal Fair Debt Collection Practices Act. And then 42 U.S.C. Section 1983, trespass, negligence, battery, assault. So all these claims are made. And the defendant removes the case to federal court saying, well, you did sue me under some federal law, so I have the right to take the case or remove the case to federal court. And then once it was in federal court, the defendant seeks to compel arbitration. And so when you move to compel arbitration, you normally ask the court to stay the proceedings. In other words, stop them, freeze them, and say, let us go over and arbitrate, which means there's no jury, there's no judge. I'm in front of maybe one person or maybe a panel of three people. They may or may not be lawyers, and they'll make the decision. So they act as the judge and the jury, if you will, in the case. And then we have this other defendant, Absolute Recovery. They join in, and then the plaintiff responds to that and says, no. You have no right to compel arbitration. And then PNC has replied to that. So that's a typical way that a motion works in federal court, at least a substantial motion. You have the initial motion, then you have the response to it, opposing it, and then the person that filed the initial motion gets the last word. That's called the reply brief typically. And the reason they get the last word is they have the obligation or the burden to carry the day. In other words, to show the judge that, yes, I am entitled to what I'm asking for. It might be to dismiss a case, to grant summary judgment, or to force arbitration. So, what do we do when we're looking at arbitration? Court points out there's a two-step process here. First, the court looks and says, pretty simple, kind of common sense, did the parties agree to arbitrate? I mean, if you didn't agree to arbitrate, you can't force arbitration. This is voluntary arbitration. When I say voluntary, I mean you voluntarily enter into it. Now, the business may say, well, if you don't agree to arbitrate, we won't do business with you. Okay, and that's a whole nother set of issues. But the point is, did the parties agree to arbitrate? And then second, if they did agree, are there any sort of constraints on whether that arbitration agreement will be enforced? And judge said, we don't have to get to the second part. We only look at the first part. And the bank says, well, look, obviously the case must be arbitrated because the finance agreement says that it'll be arbitrated. And sure enough, finance agreement, 2-page document, includes an arbitration provision. And this is pretty standard. Any claim or dispute, whether in contract, tort, statute, or otherwise. And then going on down, I'll just highlight the whole thing here. Between you and us, our employees, agents, successors, assigns, arising out of related to your credit application, the vehicle, the contract. I mean, it's super broad. That's how these things are typically worded. And then it says, the court points out, there's no signature line beneath the arbitration provision, but on the first page of the finance agreement, there is a separate, quote, agreement to arbitrate with the signature line. And then what does that say? By signing below, you do what? You agree that pursuant to the arbitration provision on the reverse side of this contract, you or we may elect to resolve any dispute by neutral binding arbitration, not by court action. Well, here's the problem for the bank. The consumer says, I did not agree to that. Well, consumer, how do we know you didn't agree to it? I never signed it. The court says, I agree. Now, the bank argues against that. So here's the first argument. They say, under 11th Circuit precedent, which just means the 11th Circuit is our court of appeals, and that is for Florida, Georgia, and Alabama. And when it issues a ruling, that's binding on the district court judges. And the PNC says, well, look, just read the 11th Circuit case law, the previous 11th Circuit decisions, that gives you everything you need to know. They say 11th Circuit says an agreement to arbitrate is only required to be in writing. It does not have to be signed, which is true. But we're going to see how the judge responds to this. And PNC goes on to say, even though there's no signature, it's still binding. And the court says, look, you have misinterpreted this Cayley versus Gulfstream case. So the court did observe that a valid arbitration agreement can be created without either party signing, but that does not mean the arbitration provision here is binding. And they say, just look at the facts of this case. And so let me get this highlighted for us. The arbitration provision drafted by the defendant employer in Cayley did not have a signature line. Rather, it said, your continued employment was how you accept this arbitration agreement. So thus, the fact that the employee did not sign the arbitration provision was irrelevant. You'd already agreed to it by continuing the employment. So here's what this decision stands for. An arbitration provision can define a means of acceptance other than a signature, and it can still be valid. Well, what does this one say? This one says Sullivan would agree to arbitrate by signing the agreement. Thus, the contract defined the means of acceptance. Well, what is that? Pretty simple. Sullivan's signature on the signature line is the agreement to arbitrate. Now, this is a really important point, not just for arbitration, but big picture here. The court is saying the fact that it could have been drafted differently. So there could have been an arbitration provision does not request signature, does not mean the agreement to arbitrate provision as actually drafted did not need to be signed. So flip that around. The court saying you could have worded it differently, but this is how you worded it, so you're stuck with how you worded it, and it says it has to be signed, and it was not signed, so you lose. Here's the second argument. I say, well, look, I found this case from the Eastern District of New York that an unsigned arbitration provision is binding, this Lovelace versus Showroom Auto. And here, the court says, even though the signature line was not signed, the arbitration provision was still binding because plaintiff had signed the bottom of the contract. And the court just says, look, I don't think this decision is particularly important, and it certainly doesn't change my mind. Notice this. The plaintiff failed to raise the argument that the arbitration provision was not binding because it was unsigned. So look, a lot of times either arguments aren't raised or there's a lot of pro se decisions out there. In other words, people file these lawsuits, particularly against mortgage companies and some debt collectors, but particularly mortgage companies, they don't have a lawyer. And so the defendant will make an argument and the plaintiff won't respond. They just don't know to respond. And so then there's a, quote, bad ruling. And then in a case we're involved in, the defendant will trot that decision out and we say, wait a minute, this argument wasn't even raised. Okay? So it doesn't matter. It's not very persuasive. And the court says, thus, the Lovelace court's discussion of this issue is pure dicta. So dicta just means it's unnecessary to resolve the case. So sometimes you'll see judges say, well, we're going to rule in favor of the plaintiff here, but we'll just go on and start talking about, we'll just sort of pontificate what we think the judge should do in the future. Or this may come up, or, well, that wasn't necessary to decide the case, so that can be ignored. So here, unlike Lovelace, Sullivan, that's the plaintiff in our Florida case from 2019, actually and persuasively argues the arbitration provision is not binding because she did not sign it. Thus, Lovelace does not convince the court the arbitration provision here is binding. And the court says, look, I agree that the plaintiff never assented or agreed to arbitrate. So state law governs the formation and interpretation of arbitration agreements. So what law is here? Well, it's Florida law. And then we have this very simple thing. A party cannot be required to arbitrate a dispute it did not agree to submit to arbitration. Kind of common sense, but you have to understand these defendants, they have, let me go off on a little tangent here. Defendants have a love-hate relationship with arbitration. On the one hand, they love it because it means they can't get popped in a big jury verdict. And they also feel like most plaintiffs' lawyers, and frankly, there's some truth to this, will just go away when there's a requirement to arbitrate. But then when we take them into arbitration and they realize the cost of arbitration and they realize they can get nailed and there's really no review of it, it's not like they can really go appeal that, then suddenly they go, wait a minute, this is so unfair. You shouldn't make us arbitrate. I mean, we had a case many, many years ago. Company forced us into arbitration. We fought it. We appealed it. The appellate court said, you got to arbitrate. So we go arbitrate. It's like weeks and weeks of arbitration. And there was a damage provision. And I may have talked about this in other videos, but a damage provision that says that all we could get is $100,000. And just to be blunt, we told the arbitrators, that's bogus. I mean, you don't have to follow that. It's just crazy that there'd be this limitation in it. And the arbitrators ignored it. Gave us a 7-figure award. Well, he would be amazed. Actually, you wouldn't be. But it was so funny because now the defendant that had fought us all the way to the top court, forcing us into arbitration, they go back into court begging the judge, please set this aside. This is so unfair. We got hit in arbitration. If we'd been in front of the court, you would have enforced that damage limitation. And this is outrageous. It's unfair. And the judge just starts laughing. And he's like, boys, this is what you wanted? You're stuck with it now. So that's why I say they have a love-hate relationship. Yeah, they're very eager to force us into arbitration. And then when bad things happen in arbitration, they want to go run to the federal judge or the state court judge and say, these terrible arbitrators, they're not actually judges. They messed up. It's too late. So anyway, that's sort of their love-hate relationship here with it. And but they tend to, sort of their knee-jerk reaction is to force arbitration, but they skip over this step of you got to actually have agreed to arbitrate. And then the next step is have to make sure the claim is within the confines of what you agreed to arbitrate. So a lot of judges in the past have just sort of rubber stamped these things and like, oh yeah, you got to go arbitrate. And so companies are just very kind of lackadaisical about it. And this is a great decision. A lawyer here did a great job of pointing out to the court, hey, my client never agreed to arbitrate. And so that was a good job by him. And then looking a little bit further in this case, so look, we look at state law governing it, but we also know federal policy favors it. But here's the Florida law. If a contract's unambiguous, then the actual language used is the best evidence of the intent. And a contract under Florida law requires mutual assent. Say, well, how about this language? Pretty clear and unambiguous. It required a signature. She never signed it, so there's no mutual assent. And then they reject the other arguments here. And this is the bottom line. Never agreed to it, can't be compelled, therefore motion denied. So again, great job by the lawyer here. And great job by the judge recognizing this is the law and enforcing the law in this case as it's written and enforcing the contract as well. So hope you found that helpful. If you're ever facing arbitration, this is a good starting point. And you kind of want to have a checklist. If you're a lawyer watching this and representing clients, you want to have a checklist to say, okay, they're raising arbitration. Did we agree to it? Is it covered by the scope of arbitration? How about are the parties the same? I'll give you an example. We had a case that we sued a debt collector and they moved to compel arbitration. And we looked at the arbitration and it defined who, like a lot of these arbitrations will say, if you or we, get into a controversy. And then it defines who we is and who you is. And you look at it, and it never said anything about selling the debt to somebody else. It says, the company is the credit card company and any agent acting on our behalf. Well, I can promise you, credit card companies do not believe when they sell debt that these debt buyers are acting as their agent, because that would make them responsible for what the debt buyer does. They absolutely do not agree to that. And so even though we had agreed to the arbitration, it only was arbitration between us and the credit card company, not us and the debt buyer that had bought the debt. So again, we have to have sort of a checklist and go through and just take every step, very methodical way to when the defendant says, aha, there's an arbitration agreement. And this is how they do it. They send you an email and they say, John, your client signed an arbitration or agreed to an arbitration, so you can go ahead and dismiss your case. I'm like, well, send me the arbitration agreement. Well, we don't have the actual one, but we have sort of a specimen copy. How do I know that that's actually what my client saw or my client agreed to? And then we go read the terms and we realize it's not drafted as broadly as maybe it could have been. And it just drives the lawyers crazy. So you've got to be really, really focused, make sure that arbitration is appropriate before you agree to it. And like in this case, if it's not appropriate, then you fight it. And so I hope you enjoyed this, and I'll catch you guys in the next video. If you have any questions or comments, sort of a general nature, put those below. If you want to reach out to us directly, go to alabamaconsumer.com or contactjohnwatts.com, JOHNWATTS, and that'll go directly to our contact page. And again, my name is John Watts, and phone number is 205-879-2447, and I'll catch you in the next one. Bye-bye.